Well, perhaps we should make a start, and thank you all for coming in such dreadful weather. This is the last of the current series of lectures on, broadly speaking, religion in a liberal state, and there'll be the final or third part beginning in the new academic year. And what I want to talk about today is the issue of call it humanitarian intervention in the internal affairs of other states. And this has quite a close link to religion, in the sense that many liberals who write about the basis of liberalism do see liberal political and social institutions as being a way of drawing the sting from religious violence or religious-inspired violence and the competition between religions within a state. And it is quite surprising to read the works of current liberal political theorists, for example, the prime example being John Rawls, the American philosopher, who in his great book, I think, called Political Liberalism, does say a good deal about how liberalism is the solvent of religious conflict. And I just want to sort of explore that idea for a minute or two, because it sets the scene in a way for the issue of intervention by other states in the sovereignty of a particular state. It's worth recalling, I think, that in early medieval times that there was a form of what's sometimes called moral universalism in Europe. After all, once there'd been the split with the Orthodox churches, the Catholic Church was, for a long time, the only final source of moral authority in Western Europe, and this was particularly manifested in the encyclical Unum Sanctam by one of, I think it's Pope Boniface VII, in which he asserted the right of the papacy to be the final arbiter on both religious and political matters when those political matters impacted on the role and function and faith of the Catholic Church. Now, of course, with the Reformation, that moral universalism fell away, particularly in the multifarious states that constituted Germany at the time. I mean, as you will know, Germany was not itself a state until 1870. And before that, it was a conglomeration of many, many states. I think at the end of the 18th century, there were 300 separate states covering the land of Germany and Austria, all under the purely formal authority, which couldn't be exercised by and large, of the Holy Roman Emperor, this kind of honorific job really by then, and he couldn't really exercise any ultimate authority over these 300 states. But of course, with the Reformation, different states embraced different forms of religion. There were many different forms of Protestantism, and of course some states like Bavaria remained Catholic. And this provoked the wars of religion in both the 16th and the 17th century. In the 16th century, culminating after a great deal of bloodletting in the Peace of Augsburg, and in the 17th century, after 30 years of intermittent bloodletting, in the Peace of Westphalia in 1648. Now, these are two extremely important dates in the emergence of our understanding of the role of the state in international affairs, because the Peace of Augsburg and the Peace of Westphalia enshrined the principle that each state should take on the religion of the ruler or the prince of the state. The principle of cuius regio eius religio, that each state takes on the religion of the ruler. Now, you couldn't really get much more of a challenge to the previous kind of moral universalism that I mentioned, because now different states will, as of right under the Peace of Westphalia, have different religious allegiances. And these states were recognized as being, however large or small they had the same competence to determine their religious character. So it didn't matter whether you were a small state, say somewhere like Osnabrück, which was basically a town, or a big state like Bavaria or Prussia. The Peace of Westphalia both consecrated the idea that the state should take on the religion of the prince or the ruler, but also the idea that states had a high degree of moral and legal equality because each state's decision about religion was to be respected as some kind of ultimate sort of norm. And out of this, over a long period, emerged the idea of state sovereignty and the idea of non-intervention. That because states had this capacity under the Peace of Westphalia to determine their own religious character, then it was not right, it was certainly not incumbent on one state to interfere with the workings of another state, because each state had this basic religious right. You couldn't appeal anymore to some kind of universal moral authority across Europe to justify intervention or war on another state. Of course, wars took place and so forth, but in terms of of looking at the history over a long period, there emerged this idea, which came to be called the norm of non-intervention. And this was seen to be an important tool in the context of religious conflict, particularly, that it was no longer legitimate for a state to interfere in the internal affairs of another state, particularly in relation to its religious character, because each state had the right to determine its own religion. So the norm of non-intervention became the characteristic norm in international affairs, and it stayed like that, and indeed was to a large extent enshrined in the United Nations Charter. There were some exceptions, for example, in the Chapter 7 issues in the UN Charter, where there's a kind of blanket prohibition on genocide and an argument for intervention when genocide was either threatened or in progress. But it did mean that the dominant norm was that of non-intervention. And along with that idea grew, naturally enough, the idea of state sovereignty, that each state was sovereign in the sense that it was not answerable to any kind of higher power, whether that power was the power of a large state, or for that matter, the kind of moral power of some kind of alleged universal set of principles, like, you can argue, existed prior to the Reformation in Western Europe. So sovereignty and the idea of non-intervention have gone together very much. And the idea of non-intervention is quite a powerful one, because, first of all, it can always be satisfied. The norm of non-intervention can always be satisfied because observing it is a costless exercise. After all, if you're not intervening, it's not costing you anything. There is no cost to abstaining from action. And because the norm requires forbearance rather than action, it can always be satisfied. You can always live by that norm as a state, because it's not going to cost you anything. All you've got to do is to abstain from intervening in another state. And this meant, according to those who favour the norm of non-intervention, of whom there are still very many, and I would have thought a vast majority of people would favour this norm, but for those who do favour the norm, it has a number of other advantages, not just that it can always be satisfied, but also, because it can always be satisfied, it is a predictable norm. You know that states in general, by and large and on the whole, will not intervene in other states because they will be constrained by that norm of non-intervention, which is also in states' interests, because after all, if my state intervenes in your state, we've breached the norm, and what's to prevent another state, not you, not me, but another state, interfering in my state? That if you breach the norm, then you lay yourself open to intervention yourself. So it's a costless norm, but it's also a norm that would yield predictable rules of international affairs and international relations. It's also a rule or a norm which appeals to small states, because after all, if I'm a small state, I might be subject to the depredations of large states. But again, the norm applies equally to every state and came to be seen by the time of the UN Charter as being a feature of state sovereignty and of the legal equality of states, that all states are equal members of the UN. If they're members of the UN, they're all equal, and they are all equally subject to the norm of non-intervention. So the strong case, as it were, for the norm is it's costless, it can always be fulfilled, it gives a predictable set of outcomes in terms of international affairs, and finally, it's it, in a sense, consecrates the idea of the moral and legal equality of states. And part of the justification for all of that is moral diversity. We no longer have, so it was argued, a set of moral principles that can be regarded as some kind of universal world morality that would justify intervention all over the place. Because we don't have that, as we did perhaps once have it, since we no longer have that kind of world morality, then non-intervention is the form of international relations which is most consistent with moral pluralism, moral diversity, and so on and so forth. Of course, one state can interfere even on the non-interventionist model. One state can legitimately interfere with another state in self-defense. And of course, this has happened. I mean, if you go back to the UN Charter, since the declaration of the UN Charter, lots of wars have taken place based upon claimed self-defense. That is the basic possible breach of the norm of non-intervention. If you can demonstrate that you're intervening out of self-defense, then of course the norm has to make way for that more basic principle where the life of a state may indeed be at stake because of a threat from some other state. But the idea, the idea still is, though, that the norm is the preponderant or paramount norm, with the principle of self-defense being an exception. And of course, many of the interventions have explicitly tried to justify themselves on the grounds of self-defense, some of them more plausibly than others. For example, when the first President Bush took military action against Panama in order to capture the president, General Noriega, this was argued that it was a matter of self-defense for the United States because General Noriega was such a large drug dealer and the drugs were ending up in the streets of the United States, then it was justified to intervene to remove him not only from office but to a prison in the United States after a trial. So that's a fairly long reach of the idea of self-defense, but that was the justification that the United States used for its intervention. Under Idi Amin, Uganda invaded a part of the territory of Tanzania, and Tanzania responded to that, and that, of course, was a much clearer example of self-defense. And more recently, of course, some of the justifications for the war in Iraq and Afghanistan have been based on the idea of self-defense, that we were defending ourselves against weapons in the case of Iraq that could arrive here in a very short space of time if they were fired in Iraq or fired on friendly countries around Iraq. And in the case of Afghanistan, we're defending ourselves against a failing state that, or a failed state that is a breeding ground for terrorism against Western countries. So the justifications tend to be based upon the self-interest of states and a recognition that there is this norm which is still very important and should be maintained. And one reason why it should be maintained, and this would be a fairly common form of agreement, is that it does protect state sovereignty, which is regarded as one of the most fundamental or primordial sort of political requirements. Now, having said all that, there is the issue, though, and sovereignty brings it out very clearly, there is the issue of, well, okay, we've lost the kind of moral universalism that Catholicism may have given Western Europe in early medieval times. But don't we have a new form of moral universalism through the doctrine of human rights? That human rights are what they say. They are the rights that people have as human beings, not as a member of this state as opposed to that, not as a member of this religion as opposed to that, not as a member of this ethnic group as opposed to that, or this gender as opposed to that. Human rights are rights that people have in virtue of their humanity. And that if you accept human rights, as all member states in the United Nations have to, if you accept the doctrine of human rights, then you have signed up for, and this is something that took some time to dawn on states, that you have signed up for some kind of modern form of moral universalism. These rights may be justified in different ways in different societies. Christian countries may give Christian justifications for the importance of these rights, and ditto with other religions, or you can just accept some kind of secular justification for them. But the issue then becomes this: if there are human rights which everybody ought to have and ought to be able to enjoy, are they rights which also should be enforceable? Because rights normally are understood as things which can be enforced, that they create obligations on other people, and that those obligations it makes sense to think of as being enforceable. So if you say there are human rights, then it seems a central characteristic of a right that it is enforceable. And we've got to think of mechanisms of enforcement. And of course, one mechanism of enforcement where there is an egregious infringement of human rights would be military action, or if you like, intervention in favour of protecting the rights of some element of the population that is being oppressed by or killed off by or whatever some dominant group in a state or the government of that state. Now this raises the question of what's the relationship between human rights, which as I say can perfectly well have a religious basis as well as a secular one. What's the relationship between the idea of human rights and the idea of sovereignty? Because after all, sovereignty was thought of as the defining characteristic of a state when we'd lost the idea of moral universalism. But if the idea of moral universalism has come back with the idea of human rights, then how do human rights relate to sovereignty? Well, the liberal position here is fairly clear. And it's set out very, very clearly by a South American thinker called Tesson, T-E-S-O-N, in his writings on this. And his argument is pretty straightforward, really, that sovereignty is a purely instrumental thing. That what states exist for, or should exist for, on a liberal agenda, is to protect the rights of its citizens. And if it doesn't protect the rights of its citizens, which is what a state is for, then its sovereignty can legitimately be infringed by other states to protect these morally universal things, which we call human rights, and the idea of sovereignty cannot stand in the way of that. The idea of sovereignty is only a kind of instrumental thing. The sovereign state may well, in general, by and large, and on the whole, be the best mechanism for conferring and protecting human rights. But of course, that makes sovereignty a means to the achievement of human rights. It's instrumental, it's not a good or an end or a goal in itself. So if you believe in human rights, then, as I say, every member of the UN has to, if you believe in that, then there must be some kind of potential conflict between the claims of sovereignty and the claims of rights. But of course, if you take the claim of right as the most basic thing, that states exist to protect human rights, including things like the right to freedom of religious belief, if you take that kind of view, then you must also see the norm of non-intervention as being a norm that is, as philosophers say, defeasible. That is to say, it's a norm that can be overridden because, again, it's not an absolute thing. The norm of non-intervention is to protect sovereignty when sovereignty is used in the right way, that is to say, protecting the rights of the individual members of a state. But if sovereignty isn't being used in that way, if sovereign power is being used to oppress people or kill people in an arbitrary kind of way, then we can perfectly legitimately abridge the norm of non-intervention in favour of what's come to be called liberal interventionism. This is very much associated now with Tony Blair. and he's quite happy to call it liberal interventionism. And liberal interventionism is this idea that states exist to protect the rights of citizens, and if they don't protect the rights of citizens, then their sovereignty can legitimately be abridged if all sorts of conditions apply, like it's not the first thing you do to try and intervene. You try to have dialogues, you try to have sanctions, etc., etc. You go through a whole list of things, but at the end of the day, you can't just say, oh, well, this is a sovereign state and the rulers of that state can do what they like with their citizens. The citizens are not chattels of government. Government exists to protect citizens in their basic rights. There is a good, if you're interested, a good account of all of this, way before the Iraq War, by Tony Blair. It's called The Doctrine of the International Community, and it was a speech that he gave in Chicago in April 1999. And you can find it on, online, as they say, and it's a very interesting sort of justification of the case for intervention as and when it may prove to be necessary, an intervention that can't be blocked by saying, well, sovereignty is basic, and which can't be blocked by saying the norm of non-intervention is basic. Both of these are instrumental goods. They may be very important instrumental goods, but they are instrumental to the preservation of basic human rights. Now, this all relates to the Christian tradition of thinking about international politics in the following way, that it's typical of the Christian position to distinguish between justice or rightness in the justification of war. We know we need to have some idea of what it is that justifies war, and that has to be a morally legitimate form of justification on the one hand. So the Christian position is we need some idea of the moral justification for going to war. And then once you've gone to war, there is the issue of morality and how war is fought and how far there can be moral constraints on how forces in a war operate. And this has come back in quite a big way in the UK because since the passing of the Human Rights Act in 1998, although it only came into effect a couple of years later, but in the passing of the Human Rights Act, one of the issues that's still troublesome is how far British troops, in exercising their use of force, are bound by the requirements of the Human Rights Act. Is the Human Rights Act a territorial thing, i.e. confined just to the territory of the United Kingdom, or does it apply across the board? And of course it's part of the idea of human rights, as I've said, that it's seen by many people now as a framework of universal values. And if it's a framework of universal values which have been incorporated into UK law, then surely it's argued by those who take this line that it should apply to the way troops behave in exercising their let's call them war-making functions, and they can be held to account according to that set of rights. So again, the idea is that there are values which transcend the kind of everyday values of a particular state, that which can be a form of international morality. Now, critics of this view take a number of lines, really, many of which I think are quite powerful. One is that it's dangerous to get over-moralized about this on the grounds that it might be regarded as part of a reasonable morality that if such and such circumstances are wrong and justify intervention in this case, then by parity of reasoning, which you can't just dismiss, such and such similar things are wrong in another case. But one case is of a small country, or not necessarily small in geographical terms, but a powerless or relatively powerless country, another which embodies exactly the same infringements of human rights, being a powerful country. Now, because you intervene in a powerless or relatively powerless country, if you're being moral about it, shouldn't you also consider the case for intervention in a very powerful country? But nobody's thinking of intervening against China because of Tibet. Nobody's thinking of intervening against Russia because of Chechnya, for example. They might do all sorts of things, make noises, might even have sanctions, but nobody's thinking of military action. And of course, this breaches the principle that arose out of the norm of non-intervention and the Peace of Westphalia and all of that, namely the moral equality of states, that doing something wrong if you're a small state is likely to attract moral censure and justified intervention on that view, whereas if you do exactly the same thing as a large state, you will be fully able to get away with it. And where's the morality in that, so critics will say. There's also the argument that because of that, because these judgments about where and when to intervene will always be contextual, it follows from that we can never have, as you could under the norm of non-intervention, a range of predictable principles of international relations. Because if you say, well, yes, we can intervene when the circumstances justify it, then when the circumstances justify it will be a matter of political discussion, political judgment, political disagreement, and so on. So we won't know in advance, as we might do under the rules of the norm of non-intervention, we won't know in advance where interventions are going to take place and where they're not going to take place, where a government feels able to, or a group of governments, coalitions of the willing or acting under the UN Charter, you never know when these things are going to take place, and will depend entirely upon the support of populations in the countries that are likely to do the intervening. It would depend upon the resources of the countries concerned, and so on and so forth. What it will create, what it wants to create, is a morally some kind of moral framework around international relations, but in the view of critics, what it will create is just anarchy, because you cannot have rules governing interventions when those interventions are costly, when local populations may not support them, and when all sorts of countervailing things come in, like, well, they're a very powerful country or whatever it might be, or they've got a lot of gas, or they've got a lot of oil, and so on. Because of all of that, wanting to place international relations on a moral basis, while it may look like the sort of Christian thing to do from our sort of perspective in the West or something like that, we might say, oddly enough, it may well produce the opposite effect because of the unpredictability that would arise out of the politics of interventionism. And we will be much better going back, in the view of critics, to the norm of non-intervention with exceptions in relation to self-defense. And ultimately, lying at the base of this in some ways is a point well made by Dennis Healey when he was Defence Secretary in the Harold Wilson government, when some issue about the morality of international relations came up. And he said, this is in the handout, which you can, the reference in the handout, he said, states are not moral entities. They act out of interests, not in pursuit of moral values. And that if you start trying to moralize international relations, you will create a very big mess because the whole thing can never be put into a coherent framework of moral rights, moral obligations, and so on. So there are these sort of big divisions. I want, though, just take another couple of minutes to talk about one linked issue that's very important, certainly very important in the Christian understanding of just war. And now I'm talking more about justice in the pursuit of war, not the justification of the war in the first place, but how you then go about fighting what might be seen as a just war from a religious or, more specifically, Christian point of view. And absolutely central in the Christian sort of understanding of this is the idea, well, it's called the doctrine, really, not the idea, the doctrine of double effect. That it is legitimate to have a moral aim in war, and that is your dominant purpose. You know, we want to free this country from this dictator or something like that. That's our dominant purpose, and that's what we're taking responsibility for. Alongside trying to achieve that through the force of arms, there will be, very, very, very likely to be, civilian casualties, or non-combatant casualties. But those are consequences which are not part of our intention. And one of the central kind of intellectual conundrums of religious moral thought, if I could put it that way, is how to understand the doctrine of double effect, that I am responsible for my intentions, but I am not necessarily to be regarded as being responsible for consequences which follow from my intentions. Now, if you take that at its face value, then it's a very strange doctrine, because there's never been a war where there aren't large-scale civilian or non-combatant casualties. And if that's so, then surely anyone unleashing the dogs of war, as Shakespeare put it, has to be aware of that. And if you're aware of it, and that it's inevitably going to be a consequence, in what sense can you disavow responsibility for the consequences and resort just to the purity of your intention, as it were? How can we just sort of say, well, I'm not responsible for those casualties because they are unintended consequences of the decision that we took to go to war? Now, that is a very difficult argument to make when, as I say, there's never, ever been a war where there are not significant casualties. And if those casualties are innocents of one sort or another, non-combatants or and so on, then in what sense can you just sort of disavow responsibility for the situation in which they find themselves? And yet the doctrine of double effect is absolutely critical to a religious doctrine of just war, because it allows you to say what would be very difficult to articulate the opposite view from a religious point of view, that we are not responsible for these consequences. Because if you were a religious person and you knew that these consequences were going to take place and you were responsible for them, then you would have quite a lot of moral responsibility on your shoulders, obviously. But this has been quite an important argument, both for Mrs. Thatcher, when she was Lady Thatcher, and also for Tony Blair in their military operations when they were in power. Mrs. Thatcher, in relation to the First Gulf War, it was fought largely under John Major, but she was still Prime Minister when all the preparations were being made for it. And then Tony Blair reiterated her point in relation to Kosovo. And the point is this: Mrs. Thatcher said, if we don't do anything in relation to the invasion of Kuwait by Iraq, then we will have blood on our hands, because we could have done something and we didn't do it, and the consequences of not doing it we are morally responsible for. Now, if you take that view, then you have to answer a previous question. You can only be morally responsible for what you have failed to do if there was an obligation to do it in the first place. I mean, if you think, it may sound a rather sort of deep thing, but it isn't really. If you just think of all the things that you're currently not doing, we're all sitting here, and there are an infinite number of things that each of us could be doing that we're not doing. Now, in what sense are we responsible for the bad things that happen because we're not doing them? I mean, I was coming here, I passed someone collecting for Macmillan nurses. Now, I could have, instead of coming here, I could have stood on a corner shaking a tin, and perhaps I would have, garnered £20 or something towards Macmillan nurses. So am I responsible for my failure to act to do a good? No, you're only responsible for the consequences of your omissions when you ought to have acted but didn't. So what you need, you can't just say, if we don't do this, we will have blood on our hands. You have to establish, first of all, that you have an obligation to do it, and in not doing it, you are then responsible for those consequences. And of course, the problem is then, how do you justify the obligation to act that would then justify the argument that our failure to act is culpable? And it's very difficult to figure out how to justify the positive argument that we have a duty to act and our failure to fulfill that duty makes us culpable. Now, the UN, largely, it has to be said, under Mr. Blair's sort of lobbying over this in the early 2000s, set up a commission to look into what it called the duty to protect. And you can see why that's important. If you think there are human rights that we all have, and these rights can only exist if they can be protected, if they're enforceable, then don't other states have a duty to protect those rights? And of course, if they have a duty to protect those rights, then the argument about blood on our hands works, Because we fail to protect them when we ought to have protected them, then we're responsible for the omission, the consequences of the omission. So the UN, and it's still struggling with this, how to figure out a set of ideas, rules, principles, and so forth that would embody the principle of a duty to protect. And the UN's still struggling with that because of the obvious point, and it goes right back to the point about the norm of non-intervention and the fact that the duty under that norm is to abstain from action, whereas the duty to protect is always going to be a positive thing. It's always going to cost. It's always going to cost blood and treasure, to use the usual language that's used in this context. It's always going to be costly. And if the duty to protect is always costly, and therefore may not be followed when the costs are too high, I don't mean just monetary costs. I mean, you know, if Russia's going to cut off your gas supply or something like that, in those circumstances, then you cannot formulate a set of rules and principles to guide international relations in the same way as you could under the dominance of the norm of non-intervention, because that is a costless thing and it can always be fulfilled, whereas the duty to protect is absolutely fundamental to the idea that human rights should now be the guiding light of international relations. It's absolutely central to that, but very difficult to articulate in a way that would cover some of these problems. You know, that you can do your best to create a moral framework for international relations, while at the same time, as it were, the doctrine of double effect strikes again, while at the same time producing exactly the opposite, namely some kind of moral anarchy, because we don't know where the justification of intervention now lies, because we don't have a clear account of the duty to protect. So, well, I mean, it's obviously far too big a set of issues to do justice to in 45 minutes, but those are some of the issues, I think, that that people who still hold to particularly a Christian doctrine of just war need to think about. It seems clear enough that a just war theory, both just war in the sense of justifying war and how you then fight a war, seems clear enough from a Christian point of view that there ought to be some kind of moral basis and some kind of moral constraints on both of those. But it's one thing saying that, another to try to figure out what they might be. So we've got just over about 12 minutes, I think, for questions. So.